Today we're going to talk about the situation where you're divorced and either you or the other party is facing a move. The first step, if you are looking at a situation where you are wanting to move, first of all, you want to sit and make sure that why are you moving? If it's a good reason, if it's something that you think would hold up as a reasonable grounds for you to up and move away from the co-parent who is the father or mother to your children, then you want to first, before you even get into it, you want to make sure that it's for good reason. For example, if you are facing an employment opportunity that is important to your career, is going to increase your financial ability to provide for your family, that's a legitimate basis for a move. Alternatively, on a different scenario, if you are in a new relationship and you want to move a few states over to be closer to that person, not likely going to be a good enough reason for you to up and move. And in fact, we'll talk about this more in a minute, but if a court decides that the move is not in the best interest of the children, even if you are sitting in the custodial parent role, custody could actually flip to the other party if the court doesn't find the move to be in the best interest of the children. And moving for another new relationship that hasn't even had the test of time, if you're getting married to that other person, that might have more credibility and weight, and the court looks at all the different factors. But you get the idea. The move has to be for a good, well thought out reason, because it is a big deal to uproot the children and move away from the other parent. So if you are going to move, you're going to want to discuss the move. You're going to give the other party, the other parent, plenty of notice. In fact, in the code it says 60 days notice in writing that you are looking at moving. And then the next step is, or the first step, once you've given them the notice, is to communicate with that person, the parent. See if you two can come up with an arrangement that makes sense, that feels good to everybody. If you guys are in agreement and can make an arrangement that adjusts and accommodates the new parent schedule, you guys can agree on how the cost of travel will be shared, then that's going to be the easiest, best case scenario. And accordingly, once you've agreed on the new arrangement, it literally can be a matter of just filing the amended decree. You reach a stipulated agreement, much like you likely did in the initial divorce process. File that with the court, and your decree will be updated to reflect the new schedule. It is important to take that step, even in an amicable, mutually agreed upon situation. You want to make sure that you get your decree updated to reflect the new schedule you're following. In the second scenario, if the other party is not facing the news that you're moving, is not accepting that or is not agreeable to it, then you're going to want to look to your decree. How does your decree contemplate a move? I know for my clients, I always factor in and contemplate what a relocation could look, what the parties will do if a relocation occurs, because it's going to save you much time and hassle in litigation later. So a lot of times a decree will contemplate how many miles will trigger a relocation. In the actual code, 150 miles or more means the party's relocating. In practical everyday life, a move as short as 50, 60 miles can have a significant impact on the parties involved, including the children. So a lot of times a divorce decree will articulate a lesser amount of miles will trigger the relocation. It would be considered a relocating event. So basically look at the decree, see how many miles, and then oftentimes it'll require that, similar to the law, that you give them 60 days advance written notice outlining, the purpose of the move, where you're moving, etc. And then the big catch that oftentimes exists in the decree is that the parties will mediate. This is not specifically in the law, in the code, but the decrees will oftentimes, if contemplated, request that the parties attend mediation. So at that point, if you've communicated to the other party, you're not in agreement, then the next step will be to attend mediation. And the beauty of that is it gets you guys sitting down to figure out the logistics of this without having to go to the cost of litigating it or involving the court. And again, it fosters that good co-parenting communication. If you are at an impasse and you don't reach an agreement on mediation on the relocation, then that gets you to involving the court. And this is also what happens if it's not contemplated in the decree. Basically, the relocation statute on point will articulate that you will motion the court for a relocation hearing. And so at that point, the parties will go to court. And as I mentioned before, the first thing the court's going to want to hear is if the custodial parent's moving, or whether it be the non-custodial, but mostly this is the situation where the custodial parent's looking at moving, the court's going to want to hear the purpose of the move, the distance, the financial situation of both parties, how far, and the court will then look at, once they've heard the basis for the move, sometimes they could just straight out decide this is not a good reason to move. If you move, you will lose custody. However, if the court hears your reasons, and hopefully at this point you have well-founded reasons, the court will then look at whether or not the move is in the best interest of the children. And they're looking at a whole host of, there's literally 3 different lists in the code of different ways in which the court is evaluating the children's best interests. They're looking at the ability for both parents to emotionally, physically, financially provide for the kids, the actual, distance that is happening, the ability of the parties to co-parent, the ability of both parents to provide for the children's needs. And in looking at the best interests of the children, they're looking at how these various things will be impacted by this move. And if the court, upon having heard evidence and having fully considered the best interests of the children, if the court decides that the move is not in the best interest of the children, if it's a custodial parent looking to move, the court could, in fact, as I said earlier, decide that if that parent chooses to pursue the move nonetheless, then the person remaining in the jurisdiction could actually become the primary custodial parent. So once the court has done the analysis as to who shall retain or gain custody facing a move, the court will then order a new parenting schedule. The court will also then outline who will bear the costs associated with the travel. So a lot of times it will adopt the default schedule outlined in the relocation statute. And generally your new parenting plan is going to look like the non-custodial parent getting the longer holidays throughout the school year. A lot of times the non-custodial parent will then have half the summer, maybe more or less, just depending on the scenario. And also the parent will oftentimes be entitled to the third or, 1 weekend a month. But ultimately the court will then order on these issues, outline a new parenting plan, and discuss the allocation of the costs, factoring in the financial situation of both parties and all of the other factors that we've mentioned. So ultimately, leaving the jurisdiction, relocating away from your children's other parent is a big deal, but life does happen. We understand, and the law understands that, sometimes jobs and other demands on a parent providing for children, they sometimes do have to move. And so as long as you realize it's a big deal and you do this, take the steps that you must. It's a lot easier to navigate, and you will have a lot better standing with the court if you give the other party proper 60-day notice in writing. You have a good reason for the move, follow the protocol, and then again, it's a court of equity, and the court's going to look at what's in the best interest of the children. So it is possible to move. Similarly, if you're the one remaining in the jurisdiction and you get notice that the other party's moving, then you need to make sure that you take action in a timely manner. For example, if you receive a written notice that the other party's moving, you want to make sure you take action and do something within that 60 days, rather than letting them move away and then a year later saying, this is not working, I never see my child, logistically it's impossible, and it's, the children aren't doing well. It's going to be a lot more difficult to deal with that a year later. Not impossible. Again, the court's always going to be looking at things from a perspective of what's in the best interest of the children. But I just caution you, make sure you do it in a timely manner, because everything's going to be easier on everyone. It's always better to just follow the steps that are outlined either in the decree or in the law, in terms of what it means for a parent to relocate. First of all, we've attached the link below as a reference if you would like to take a look yourself at the relocation statute, or if you'd like to speak with us specifically about your case, then go to my website at jrlawgroup.com, where you can schedule a consultation and or give us a call. And as always, follow us on Instagram at jrlawgroup, and we'll see you next week.